Good morning, everyone. Welcome back to Neat Law, your legal classroom on the internet. I'm your guide through the maze of law. Today, we continue with part 2 of internal aids to interpretation of statutes. In our last session, we discussed aids like the preamble, titles, headings, and provisos. Now, let's go deeper into the remaining internal tools: illustrations, explanations, exceptions, saving clauses, and a very important comparison: exception versus proviso. So, let's begin. Illustrations, clarifying the application of a section. First, we have illustrations. These are examples inserted by the legislature to demonstrate how a provision would work in real scenarios. Though illustrations are not a part of the main enactment, they are extremely useful in understanding the legislative intent. Take Section 76 of the Indian Penal Code, for instance. It talks about acts done by a person bound by law. The illustration that follows describes a soldier who fires on a mob under the command of his superior officer, thinking it's lawful. This helps us understand how Section 76 would apply. So, while illustrations are not substantive law themselves, they're persuasive. They help in clarifying vague or abstract provisions. 2. Explanations, expanding or clarifying provisions. Now comes the explanation. Think of it as a magnifying glass. It's inserted to clarify the scope of the section or define ambiguous words. Let me give you a strong example. Section 108 of the Transfer of Property Act contains explanations clarifying what constitutes material deterioration of property. It ensures the section is not left to subjective interpretation by courts. Explanations are considered a part of the section itself. They can restrict, extend, or define the meaning of certain terms. Importantly, they prevail over the main provision if there's any conflict, because they are inserted with the intent to resolve ambiguity. 3. Exceptions, removing specific cases from the general rule. Next is the exception. Exceptions remove certain scenarios from the operation of the general provision. It's like saying, here's the rule, but it won't apply in this specific case. For instance, Section 300 of the IPC defines murder. However, it has 5 exceptions, such as sudden and grave provocation, under which the offense is not considered murder but culpable homicide not amounting to murder. So, when you're interpreting a statute, always read the exception with the main section to avoid overextending its application. 4. Saving clauses, preserving previous laws or rights. Fourth, we have saving clauses. These are protective in nature. They are often inserted at the end of a statute to preserve certain existing rights, laws, or procedures that might otherwise be affected by the new law. A good example is Section 6 of the General Clauses Act, 1897. When a law is repealed, Section 6 ensures that anything done under the old law is not invalidated unless the repealing law explicitly says so. So, saving clauses act like safety nets. They make sure the transition between old and new laws doesn't cause injustice or confusion. 5. Exception versus proviso. Know the difference. Finally, let's tackle a very popular exam and interview question. What's the difference between an exception and a proviso? Though both appear to limit the general rule, they operate differently. An exception completely removes certain matters from the scope of the section. It's as if the rule doesn't apply at all in those cases. A proviso, on the other hand, qualifies the section. It applies, but in a limited or conditional way. Here's an analogy. Imagine a rule that says, all employees must work 9 to 5. An exception would say, except interns, they are not required to follow this rule at all. A proviso would say, provided that employees working in field roles may work flexible hours. So, the rule of interpretation is, exceptions override the section, while provisos restrict but do not nullify it. To wrap it up, all these internal aids, illustrations, explanations, exceptions, saving clauses, and the distinction between exceptions and provisos, are tools that help judges interpret statutes without consulting external materials. They safeguard the legislative intent, clarify language, and ensure justice. As future lawyers, you must always read the bare act not just line by line but clause by clause. Internal aids are not decorative, they are interpretive gold. If you found this helpful, follow Neat Law for more legal deep dives made simple. And don't forget, interpretation is not about what the law should say, but about what the law does say. See you in the next class.